Welcome to POPLAW Podcast. I'm your host, Desiree, and I'm still not your attorney. This is POPLAW Breakdown. POPLAW Breakdown is a segment of the show where I break down the law related to guest episodes. But we're going to switch it up a little bit. Typically, we go fully through the law that we talked about, but so many people wanted to know more about the Workday lawsuit on the episode with John Passmore. So let's talk about that a little bit more. If you recall, Derek Mobley is the named plaintiff in a class action lawsuit brought against Workday. You heard it right. Workday is the job engine that uses an AI software to screen candidates when you're applying for a job. According to Mobley in his claim, he was getting rejected because he was black, because of his age, because he went to an HBCU, and also because he had some depressive disorders or other mental health issues, and immediately he was getting rejected for these jobs. He discovered that this was true because sometimes he would get rejected in the middle of the night or even immediately right after applying. And also he got rejected for a job that he was already doing at the same company. Well, this went to court. The court decided that some of the claims that Mobley brought were being dismissed. However, other potential claims were allowed to go through, and now the case is in discovery. So discovery means that the attorneys can go dig up all of the tea. A little bit more about this class action lawsuit. With him being rejected for over 100 positions, again, he was saying that it was discriminatory and it violates Title VII of the Civil Rights Act, and also is in violation of the Age Discrimination Employment Act and also the Americans with Disability Act. And those are federal acts that allow for companies or disallow for companies to discriminate. This claim is also significant because the EEOC wrote an amicus brief, and that is a letter in support of Mobley's claims, which allows it to go through. And as we mentioned in that episode with John Passmore, the EEOC recently won a discrimination lawsuit for a different litigant using AI software and their discriminatory hiring practices. So this is really important. Now, while AI is all over the place, different companies are figuring out the models and tools and how to train these models. There are some actions that companies and lay people, us, the employees, can take to try to prevent discriminatory biases with these AI models or in our job application search while we are all figuring out the new world of AI. So something that the companies can do to protect themselves is to look at their contracts with the software providers, these AI tool models, and make sure that they put in non-discriminatory language, that the model has to be trained and have more parameters around it. If they are unable to retrain this model and feed it different information, a great contractual thing that they can do is to change up their indemnification provision. So personally, if I was representing the company, I would say, make sure that that indemnification provision, again, is strong. And if any lawsuits come against me as the company about discrimination, well, the AI tool is responsible and they have to pay any money damages that I would, as the employer or potential employer, would be responsible for. And as far as those lay people who are applying for jobs as W-2 employees, lie. No, we really don't want you to lie on your applications, but while there is bias, maybe a smart thing to do is to not reveal your race, not reveal your age, and put NA or refuse to disclose when you're going through these job applications. It's a crazy job market right now, and I know we will all hate to just be rejected at the screening phase before our true capabilities, our true intentions, our true skills are given a fair shot based on a biased AI model. Remember, I am not your attorney. This is strictly for entertainment purposes and is not to be considered legal advice. See you next time on a POPLAW Breakdown. Bye.